Good afternoon. I'm attorney Allison Tilton from the Gray Legal Group. I'm going to give Michael's normal spiel because he's not here today for our lovely video. So let me just let you know that the information in this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt or viewing does not constitute an attorney-client relationship. So with that said and out of the way, let's start with our first question. Let me let you know that the topic this week has to deal with property. We've got two questions. The first question says, my ex and I have a divorce judgment. We wanted to split, I apologize. We agreed to split his retirement. I sent our judgment to his retirement plan and I got a letter stating they can't pay me. What do I do? Okay, so first off, I think what this question is saying is that the retirement plan indicated to wife that the plan couldn't pay her because she had only submitted to them a judgment. What that means is the judgment itself is going to award a party a right in property rights with relative to the retirement, but it does not direct the plan administrator to pay out the retirement benefits to the other party, which is typically known as the alternate payee. What those parties need is a document that's generally referred to as a qualified domestic relations order, sometimes a stipulated domestic relations order, sometimes a retirement benefit order. But what this document is a secondary document that's done post-judgment, and it directs the plan administrator to pay out the participants' benefits to the alternate payee. So that's probably why the plan said that they couldn't pay you. Is because you didn't have this document. So if you get one of those documents completed, our office prepares qualified domestic relations orders. We could assist you in something like that. Once we have that completed, we send it off to the court as a court order, and then to the plan, and then the plan can pay you whatever retirement you were awarded in the judgment. All right. The second question, I bought a house while we were married. Only he's on title. Is this his property or is it community property? So what this tells me is that these parties are in the midst of their divorce, or they're contemplating a divorce, and they're trying to figure out whether or not their property is community property, separate property, how they want to divide it. A house is a really unique asset because the house is actually probably husband's separate property, even though it was acquired during the marriage, which is a deviation from our normal community property rules. Our normal community property rules say that property acquired during the marriage, from date of marriage to date of separation, other than by unique, because when you buy a house, you record a deed, and that's a title document. And for one spouse to not sign that deed, they would have to sign an interspousal transfer deed, which is referred to as a transmutation document. Transmutation document is a document that says, I'm going to give up my rights to community property and essentially forfeit those rights and give it to the other party to be their separate property. And we're going to change the character, which is what that transmutation is. So with that being said, the house is probably his separate property, but the community may have acquired some type of interest in that house. What we would be doing is looking at what was the source of the down payment, were those community property funds, further, who paid the mortgage on the property. If the community pays the mortgage on a property, then the community is entitled to an interest in the separate property with regards to the principal payments that were made on the mortgage. So like I said, housing is unique. Other assets, our title does not necessarily control. If, say, for instance, this was a car and it was only in one person's name, that car is probably community property. So a very unique type of asset. If you have further questions regarding property division and whether or not an asset would be classified as community property or separate property, feel free to submit those questions and we can address that in another broadcast. So those are really the only questions that I have right now regarding property. So again, thank you for joining us on Ask a Lawyer. Join us each week as we discuss the family law issues important to our community. If you have a legal question or a topic you'd like us to address, go to thegraylegalgroup.com and click on Ask a Lawyer. And we will be back next Tuesday at 1:30 p.m. to answer your legal questions.